Welcome to the Professionals of the Inland Empire show with your host, John Tulac.
And welcome to Professionals of the Inland Empire, which you know by now if you've been a regular listener, we affectionately call PI. I'm John Tulac, international business attorney located in Claremont, California. It's my privilege to bring you each week one or two professionals who live and work in the Inland Empire, serving the greater Inland Empire and you, the business person. Today, I am really pleased to have a very special guest, the now retired judge, the Honorable John Pacheco, who served for quite a long time in the San Bernardino court system and was simply a fabulous judge. And he's now in private dispute resolution through Signature Resolution Services. We're going to talk today about resolving disputes through mediation. So welcome, Judge Pacheco, to Professionals of the Inland Empire. And ladies and gentlemen, sit back for the next half hour, enjoy a slice of pie. Here we go. So Judge, tell us a little bit about being a judge and how you made the transition to private judging in mediation and arbitration.
So I'm sitting in a courtroom trying a case by the name of McCown versus Walmart. It was my only case that ultimately went to the Supreme Court, in which my client got a favorable ruling. And it was dealing with the issue of vicarious liability. And after I tried the case, my client was very happy, and we were at Applebee's celebrating when the then presiding judge came over to me and said, "John, I want you to put your application for judgeship." And I was totally shocked that he would even ask me. I had never even considered being a judge. Quite frankly, I didn't feel I was qualified. And he said, no, put in to be a judge and go through the whole process. So I did, and I talked to my wife before I did, and it was a tough decision because being a judge at that time, it was a huge cut in pay compared to what I was making, like 5 times more. But, you know, thank goodness we had some assets and we had some savings. So I put in my application and got appointed. My first job was out in Joshua Tree doing criminal cases. And it was quite interesting having to take the 92-mile drive every day and back from Riverside area. But I really loved it and really got to understand how important it is for a judge who maybe have specialized in one field of law to jump into a different field of law and to be a well-rounded judge. It's to me, a judge isn't just a judge for one area. They may excel in a certain area, but a judge, when we go to judges college, it's a 2-week intensive course. They give you all the general areas of judging that you'll be doing, and it's very eye-opening, so to speak. The problem is that they have almost a year delay right now. So you'll get elected and appointed as a judge, and you'll be on the bench for about a year before you get sent to judges college. So it can be quite distressing, so to speak. But it's been I was 22 and a half years as a judge. Absolutely loved it. I just tell you, it was such a sense of satisfaction having wonderful lawyers such as you, John, who I consider a fabulous lawyer, come before me to resolve disputes. After 22 and a half years, I thought to myself, I wonder, yes, it's time to retire because I have grandkids, but I wanted to stay busy and in and around the legal profession. And so I was scouted by several ADR, alternative dispute resolution firms. And the one that really tickled my fancy was Signature because of the classiness, the neutrals that were involved are just a top notch. And the more I spoke to people, friends of mine around the community, they all said, no, Signature resolution is the best place to go. And so I was courted by a judge by the name of Buckley, who was the presiding judge of Los Angeles. He actually came out to my boat in San Pedro, and we went out and had lunch. And he said, "No, I think you really would fit in doing mediations and arbitrations." The difference between signature resolution and the other ADR services is that in signature, basically you will do well if you have a good book of business. In the other dispute resolution companies, they often will just hand you cases, arbitration type cases that perhaps have been written into the contract for, since this is a business uh, 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 presentation, a lot of companies have waivers or have people sign an agreement to waive your Seventh Amendment right to a trial and forego that and go to mediation. And sometimes it's written in, it tells you which mediation company you shall be attending. So while I am a big American Board of Trial Advocates person, and one of our main principles is the right to a trial by jury, I also, as a judge, saw how important it was to resolve your disputes informally to avoid 5 years of costly trial uh, and time. And then the doubt that you might have if the case goes into, it gets appealed. And so you could be looking at 7 years from the day that you file your lawsuit until you finally get a resolution. So it is, mediation's a much quicker, better way to go. And if you have a good mediator, it can bring in the facts, analyze it for you, and do a good presentation and make some recommendations about getting it resolved. I apologize. I could talk all day, but go ahead and ask me some questions, John.
Well, that was what I wanted you to start with, is a little bit of the background and how you got to where you are today. It's important, I think, to explain what mediation is, because I still know that business people have heard the term, and it's been around now since the early 90s. And it's not the same as arbitration, and it's certainly not the same as resolving a dispute by submitting it to a jury of your peers, or a bench trial where the judge is deciding. In mediation, the parties are deciding, and the mediator is helping them do that. So give us a little explanation of that process.
Correct. That is the beautiful thing of the mediation. Arbitration is very similar to a court trial. There are the grounds or the rules of no ex parte communication between one party without the other party being present. In a mediation, all things that are discussed are, there's a confidentiality privilege, and all those things are confidential. So for instance, I just handled a business dispute last week. The person, it was dealing with palm trees, and I'm talking 500 to 600 palm trees. And they were doing a remodel down in San Diego Airport. Uh, and they had been litigating this case for 2.5 years and had not been able to get anywhere. So they finally decided to come to mediate the case. And it was really good because I got to find out what was really eating at the plaintiff, uh, and why, he really was angry at the defendant who was supposed to buy these palm trees from him. And once you get down to the nitty gritty and find out what's really bothering the person, then you can try to think outside the box and work out a resolution. In the case that I just settled last week, there was not really a change of money, but there was an agreement for them to engage in what they had been doing prior to, but we set some more boundaries so no one could back out of things. And so it was a very successful mediation. The parties were very, very happy at the end, and they were able to get on with their life without having to pay the hourly amounts that so many lawyers charge. Um, and that's what happens in business disputes. You get involved and you're paying sometimes up to $800 to $1,000 an hour to have the services of a good lawyer. And so that's why it's benefits businesses, in particular smaller businesses who can't afford to pay $200,000-300,000 in attorney fees through through years of dispute, and then you go to trial not knowing if you're going to win or lose. So there's some beautiful benefits, and one of the things that I've noticed, having done mediations for 2 years now, is the confidentiality is so important. You're able to really get them to trust you, and they can really tell you what they need. And once you have that, then you can work on the other side and do the same. And then you work at a solution. But what you said, John, is right on. You bring the parties to a resolution, sometimes through a mediator's proposal. But the point I'm making is there's no, you kind of knock down all the anger, the hostility, all that. You knock down, you get away from that. And so that you guys resolve a dispute amicably, where everyone walks away friendly. In fact, like this last case, they started doing business again. All these things are important because in the long run, you can fight, 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 but really sometimes no one ever really wins the war.
Right. Sometimes after an expensive and long struggle in court, even when you win, you feel like you've lost because of the time, the burden, the stress, as well as the financial cost. And unfortunately, it sometimes seems like Bleak House, where the lawyers are the ones who end up with everything, and a judge or a jury makes a final decision, and say there's an emptiness afterwards. I've always said that the parties generally know what the right outcome is, but things get in the way, anger or some other underlying issue, none of which ever gets addressed usually in a trial because it's only about the bottom line, who wins, who loses, and how much, if the plaintiff wins, is going to be awarded. Where in mediation, as you say, in confidence, you can talk to a mediator who's going to, a good mediator is going to listen to you carefully, right? And let that set piece story come out in a natural way, as opposed to the question and answer, examination and cross-examination way of doing it in court.
And sometimes it's even as simple as maybe a little bit of money, but an apology. Uh, an apology can go a long way sometimes. The fact that a lawyer gets involved and the lawyer will say, don't you ever apologize or make excuses for anything. Deny, deny, deny. This is the way we go, and this is how we're going to litigate the case. But once you open up the case, you open it up and you start showing, okay, this was not realistic in your demand. We need to really come together and try to get this thing resolved. Once you break that down, then that's how it works. Also, you want to point out, John, that being involved in the courts for 22 and a half years, I could tell you the backlog that is constant problem, not just because of the pandemic, but because there's just so many cases that are getting filed and there's not enough courthouses or courtrooms to try the cases. And it causes a lot of frustration. The other thing that causes issue is people who are not used to going into court every day. It's very intimidating to them. And that as a result of that, sometimes they may be a little inhibited or not wanting to come out and express their true feelings, which you can do in a mediation under a confidential setting.
And sometimes, yeah, we should probably talk a little bit more about process. The typical way a mediation, at least as it was originally envisioned, started with a joint session with everybody all together. The parties, either in advance or in that first session, framed the agenda, gave the mediator a sense of what they want to do, issues to discuss first, and so on. And then later you would break into private sessions or private caucuses. And that's where you could really let it hang out. You could say what you didn't want to say directly with your opponent and counsel in the room. And I always thought that was a very, very good process. I liked it when I was litigating, and I liked it as a mediator to always start with a joint session. Let everybody understand that you may hate each other, but until you resolve this problem, you're stuck with each other. So
Right.
that could be an extra motivation. So my question for you is that lawyers don't seem to understand the value of a joint session. They want to go right straight to private caucusing
Right.
and not let the clients be in the room together with each other, even under the very strict control of a process. And I don't get that. I honestly don't understand, other than the I need to control my client kind of thing, lest something be said wrong. But clients have a right to speak in mediation. In fact, should do a lot of the speaking, right?
100%. And you talk about joint sessions. Um, it's kind of, for me, it's kind of rare that I have a joint session, especially if there's a heated dispute, because what that could happen, and it has happened for me, is it creates more animosity when they have to come face to face with their opponent. And they have this, like, they have to put this facade of whatever, hate or anger or, abstinence to say, I'm not going to do anything you want. And that can create some blocks. So what I invite the attorneys to make sure you give me a brief setting forth what you believe are the issues. And if you feel that there's some really sensitive areas, I say, let's have a little conference. Of course, it's confidential. Let's have a little meeting so we can talk about it. Because sometimes the lawyers may want something, but they're having a difficult client. And then he'd say, Judge, you need to help me move this goalpost here so this client will understand how we can resolve this matter. So that is, like you said, John, having them feel comfortable speaking to the mediator, feel like, hey, I trust that there's confidence here and what he or she is going to share or not share. And you can move forward that way. So that way it breaks down things. And as time goes on during the mediation, after going back and forth between the rooms, they start to realize, okay, I kind of get where they're coming from. And the other side says, yeah, I kind of get where they're coming from. The whole reason that you go to mediation is hoping to resolve it, not to create more animosity. And so that's always a good thing, that you're going there with the idea that we're going to try to resolve this if possible.
Yes, and again, it's different than a settlement conference where the judge can bang heads together
Yeah,
in chambers. You never would see that kind of conduct in open court, or at least rarely anyhow.
right.
But in mediation, that's not the job of the mediator. Even though a lot of mediators are in fact retired judges, that sort of strong-arm tactic is not really what you do. Instead, it's persuasion and patiently listening and getting the parties to open up so that they can then help you give them a pathway to figuring it out for themselves.
That's exactly right. And the the issue with a judge who is on the bench, who uses sanctions as a sword, uh, does not go, will not be a good mediator in real life. You just can't. It's resolution by amicable resolution, being in tune together. You can't just be screaming at one side and saying, you need to come up with this and you need to do that. It does, number one, even if it gets resolved, the parties are not going to go away happy. They're going to be very upset that, it was a very hostile mediation. And that is not the key to success, to being a successful mediator. You need to, and sometimes I will take the hit. They want to blame somebody, blame me, accept the case, get it resolved. You can blame me, that's fine. But guess what? Your dispute is resolved and you're done. And you can move on with your next chapter in life.
Right. And I think that's the hardest thing for the client, even though the lawyer should be telling them ahead of time about what a mediator does and doesn't do and how the process works. They still see the mediator, especially a retired judge, as the authority figure. Sometimes they're actually kind of hoping, I think, for someone to tell them what to do. But that's not the mediator's job.
Right. You guide them, you give them direction, saying, did you ever consider maybe taking this approach? I'm not saying that you have to take that approach, but think about the benefits if you did take this approach, how this matter could get resolved by doing this. And it kind of opens up because, you want to, like I said, you want to break away all this, the feelings of anger or the dispute is causing a lot of stress. You want to break that away and get them to start thinking in a positive way, not a negative way, but a positive way. I mean, I've heard, some litigants will come to me and say, Judge, I'm going to screw this person. I'm going to screw them as bad as I can screw them because they messed up my business or something to that effect. You got to dig through and find out, well, what did that person actually do, and why did that person do it? And then you start figuring out, okay, there was partially some reason why that person stopped payment on that check. There's reasons for things, and I don't know if some of you remember, John, there was this announcer on radio, always on a talk show, and he used to always say, and now, folks, here's the rest of the story. I don't know if you remember, and it was, as a judge, that is critical that you hear and understand both sides. Because once you do that, then you say, there's the rest of the story. And it still happens to me to this day. I will read the plaintiff's or the claimant's brief, and I'm like, there's nothing to decide here. This case is 100% slam dunk. Then I hear the respondents or the defendant's side, and I'm like, oh my gosh. And you get right in the middle and you say, okay, now we got to figure out how we're going to get this thing done. So that is just like it was for me as a judge. I consider myself like a servant to the people I serve and try to make them feel that they are getting what they want out of this case.
I always thought that there were two stories that have to come out before a case settles. One is the set piece. Until you have that set piece said,
Right.
the client has to be the one to say it. They can hear their lawyer say it, but and even the lawyer might say it better. The client has to say it before the client can feel satisfied and feel heard. And the other is, as you described it, it's the backstory. There's always something more at the root of what the dispute is than the set piece is going to tell you. And sometimes you don't get anywhere until both of those things come out.
And John, I want to introduce another factor that comes into play. Actually, two factors. One of the factors that comes into play sometimes, and I was taught this by my mentor attorney, Florentino Garza. He says, John, there's two types of lawyers. There's lawyers that try cases based on the facts that they have, and then there's lawyers that try cases based on the facts that they make up. So that
Fortunately.
that happens, and you have to, as a mediator, you have to realize who is who is driving the car here. Who's driving the dispute? Is it the lawyer who's going to earn more money charging on an hourly rate, or is it the client who's is driving the case? And once you set aside the lawyer and you tell them, look, it's about your client. It's not about your pocketbook. Unfortunately, in family law, you see it time and time again. These family law lawyers will come in and they'll just gobble up hundreds of thousands of dollars. And then when the poor litigants are out of money, they say, I'm subbing out, I'm done. And they end up settling the case that could have been done through mediation for hundreds of thousands of dollars less. And the case gets resolved and people move on with their life much quicker. So that's one. The other thing comes when you have an insurance company who holds the key to the money, and they sometimes may not necessarily be doing what's in the best interest of their insured. And that can be very, very, very questionable and very tricky. And you got to be very careful how you walk that line. Because I even tell the insurance companies, look, it's about your client. I understand that you have the money you're paying, but it's about your client. Can you imagine if you don't settle this case and the case goes to trial and your client gets hit for an amount that's larger than what you insure them for? Now you expose them to their own assets. And that is called the covenant of good faith and fair dealing. You don't do that, because then you run into what is known as bad faith. And so you need to separate that. And sometimes you need to kind of politely remind the insurance company, you got to be careful what you're doing here, because you're exposing your client. I know, because you have handled hundreds of these cases. I know you think that it's going to go a certain way, but every case is different. When I have a good lawyer like you, John, on one side, I know that the other side better be able to pony up some good money on your case, or they're going to be in trouble. Because I know what you're going to do. You've been around a long time. You're not what do you call wet behind the ears. You've been doing it a long time, and you're not going to have your feathers ruffled so easily. I don't care if you have international lawyers that come before me. You don't get your feathers ruffled, and that's good.
Well, it doesn't do any good constantly fluffing your feathers at somebody who'll just fluff them right back at you.
Right.
Yeah,
Right.
so don't. Yeah, that was a joke that we used to have. Don't ruffle your feathers at me. I'll ruffle right back.
Right.
Yeah, to me, facts always come first, and lawyers, especially young lawyers, forget that. They've had 3 years of studying law intensely, but they forget that before they get to the Hornbook law and the rule of law in a case, they read a procedural posture of the case, and they read a summary of facts that were, ultimate facts. These were what were determined, but
Right.
ultimately, in the real world, you have to figure out the facts most of the time first before you can get to apply the law properly. So I always say, until you know the facts, you don't know what you're doing with the law. And
Right.
you can certainly waste a lot of your client's time and money playing games with cases and statutes that don't focus properly,
Right.
which is good for
And
billings, but nothing else.
exactly. And I did an article, and it was dealing with uh, uh, as as lawyers, they are bound to represent their clients zealously. But there comes a point in time where you can become a zealot. And once you do a zealot, you've crossed the line and you are not doing what's best for your client. Just because I'm new, I want to make a name for myself, I'm going to go beat up the other side. Well, you need to be careful, because it's not about you, it's about your client. And I would just strongly advise any business people are listening to this podcast, that they need to get the lawyer that's going to listen to you. And they need to get the lawyer that's going to get what you want, because at the end of the day, John, it's always about your client.
It is always about the client, and the client needs advice, because the client doesn't always know what the rights are, remedies, and also needs to know about the risks.
Exactly.
It's like, you may have a case here, but it's not a slam dunk winner, and too many times they get pushed along. It's like we're going to get this, and then it's not a happy outcome because they weren't realistic in assessing the facts and the evidence in support of the facts. It's like, yeah, you can argue that, but the other side's going to argue it differently. And if you don't assess those properly, and I've seen this in both sides. Actually did some legal research, going to write a law review article about it, but I couldn't get lawyers to cooperate candidly with me to do it the way I wanted to. Both plaintiff lawyers and defense attorneys routinely overestimate their chances for success at trial. That was my hypothetical. And a lot of anecdotal evidence to prove it, and a lot of stuff reported in the Daily Journal about settlements and outcomes of trials and the comparing of the two.
Yeah.
It's like, yeah, today you can see it without the need to do the research and write a law review article. But that is why you end up with a lot of unhappy clients, even ones who win, is
Right.
they've overestimated what their outcomes were going to be.
And in a trial, um, you always look at the person who's going to be asking for something, usually money, what kind of impression he or she makes, how intelligent they are they going to be likable to a jury? Are they being unreasonable in their request? Are there any inconsistencies? Those things all get evaluated to a jury by of your peers, and it's can be very powerful. So you never know going into a trial, how good it's going to come out. There could be a really good lawyer on the other side that's really good about cross-examining your client and making your client not look so credible. With mediation, I do the same thing. I cross-examine the person who's asking for money or asking for something, and I figure out what kind of impression would this person make. I also, in speaking to the lawyer, I figure out how prepared, how good is this lawyer going to be if the matter goes to trial. And then on the other side, I do the same thing. How good is the other side? How good is their lawyer? And that goes in my evaluation when I try to mediate a case. You can have a lawyer that's very green behind the ears or wet behind the ears and not know what they're doing. And a good experienced lawyer will take them and just whip the heck out of them.
And the opposite is true. You can have an inexperienced lawyer who preps and preps and preps, and an experienced lawyer who says, I can beat this kid. And then it turns out differently. So again, the preparation is something that's so essential for both the client and the lawyer to be ready for mediation. I mean, it's so stupid to spend the money and the time for getting someone with the experience of helping people resolve disputes and then not prepare properly for the mediation and come in and try and wing it. That's just really dumb.
Right. Well, just to give you an example, today when I was doing a mediation, plaintiff's counsel did not have a very critical document, which was a medical record of the client treating to the exact same parts of his body 6 months before the accident, making the same exact complaint. And the lawyer did not have that document, but the defense did. They had the document. And I'm sitting there because there's confidentiality. I'm trying to say, are you sure that you have everything you need to get this case to go to trial? I mean, I can't tell them, look, there's a document out there that's going to just destroy your client's case. But I have to, try to push him to get the case resolved. So yes, being prepared is very, very critical.
So in a couple minutes that we have left, what would your advice be to a business person with a dispute and looking for a lawyer who's going to be amenable to getting it to early mediation as opposed to simply filing a lawsuit? How does that business person make that move happen?
Well, the first thing is, like I mentioned previously, sometimes employment contracts, even you go by a phone, a lot of these things, there's already an arbitration agreement written into the contract. So oftentimes, if that's done with a bigger company, yeah, you're going to get into arbitration. You're not going to have a trial by a jury. You want to I guess what you want to do, and when you're the lawyer and you're the business person, you want to figure out if this business person is knows the area of law that they're dealing with. Is it okay to use your expertise, John?
Sure.
So in your case, John, that we mediated, you're, I mean, this case was about turbines, and you were like an expert in turbines. You knew the ins and outs and how long they last, how the value is. You knew so much more than the other side, who they just brought big gun lawyers who didn't know nothing about turbines compared to you. And so while they try to put up a big front to their clients, clearly you were so far advanced in the knowledge of that, it just made it easy for me to go tell the other side, I don't know that you're going to be able to prevail on this case, given the situation. These cases, those turbines have been around a long time, John, and you sure know a lot about them. I appreciate you educating me on it.
Well, that's what we were talking about, is preparation. If I don't know something, then it's my job to learn about it. In that particular case, I'd had a lot of prior experience with power generation. So and one of the reasons why I was hired is because of that prior expertise. So I appreciate the example because it's a good way to tell people that your case is only as good as your ability to put it on, but it's a lot easier to put it on in closed door sessions in mediation than it ever is going to be at trial. Judge Pacheco, I want to thank you very much for being my guest today. As you can probably figure out, ladies and gentlemen, we could talk about this for a long time, going through strategies and tactics, all of which would be a lot more fun probably for the lawyers than for you. So I'm going to say so long for now, and thank you for listening.
Thank you.
Thanks for watching or listening to, depending on the case, the Professionals of the Inland Empire show with your host, John W. Tulac. If you have a suggestion for a guest, email him at jwtulac, that's JWTULAC, @gmail.com. jwtulac @gmail.com.